Good afternoon. I'm Roger Lewis, Chair of the Chicago Appleseed Center for Fair Courts Board of Directors. Thank you for tuning in to our second Collaboration for Justice event this month. Every year we gather for our annual luncheon in October. Since we can't be in person this year, we've planned events to shed light on some of the hidden injustices in our court system. On October 5th, Sarah Stout, Garion Gatewood, and State Senator Robert Peters discussed the Pretrial Fairness Act and the end of money bond in Illinois. Today, we have a dual-keynote presentation by Illinois Attorney General Kwame Raoul and Chief Justice of the Illinois Supreme Court, Honorable Anne Burke, who will discuss eliminating disparities and improving the Illinois courts. Before we get started, I would like to give some context to the work we do and explain why we do it. The Cook County Circuit Court serves Chicago and the surrounding suburbs. It is the second largest court system in the country, with more than 400 judges presiding over 1 million cases filed in both the criminal and civil courts each year. Around 90% of the people prosecuted in Cook County are considered indigent and are therefore represented by the public defender. Most of these individuals are people of color, with 75% of people in Cook County Jail being Black and another 16% being Latinx. According to the Illinois Supreme Court, about 75% of all civil legal cases in the state involve at least one party who does not have a lawyer. Without equal access to legal representation, people do not have equal access to justice. This is just one of the many ways our courts systematically punish people for their poverty. Today, over 10 million people in the United States owe a debt to the court, totaling over $50 billion collectively. In Cook County, 51% of people who owe money to the court have children, and 2/3 have an annual income of less than $30,000. Chicago Appleseed Center for Fair Courts is working to create a system that is accessible to all people, regardless of race, gender, ability, citizenship, or socioeconomic status. We are a volunteer-led research and advocacy organization focused on making sure that people without legal representation have the same opportunities for justice as those with it. In collaboration for justice with the Chicago Council for Lawyers, Chicago's Public Interest Bar Association, we advocate for anti-racist policies and practices that make the system less harmful, conduct mixed methods research to support community perspectives with data, educate people on how to best access their rights in court, and teach lawyers, legislators, and activists how to fight for these rights for their clients, constituents, and communities. Together, we fight for a legal system that is equitable, accessible, and fair to all people, efficient so justice is not delayed, and effective in seeking solutions to social injustices. In the past 25 years, the Collaboration for Justice has promoted systemic reforms that improve both civil and criminal court processes, focus on immigration and criminal justice reform, family law, police accountability, and projects in the federal courts. All of our work falls into one of these broad program areas, which are led by groups of between 10 and 120 volunteer lawyers, academics, and organizers who meet monthly and cumulatively provide thousands of hours of pro bono work for our collaborative initiatives annually. We are successful in promoting fair and effective court policy because of the volunteers, donors, and community partners that support our mission. Although we've made great strides this year with our coalition partners, such as passing the Pretrial Fairness Act, which will end money bail in 2023, and the Joe Coleman Medical Release Act, which sets up a system of compassionate release in Illinois, there is so much more to be done. I hope you will consider supporting this work by using the donate button below or making a contribution at chicagoappleseed.org/donate. Over 40% of our operating budget comes from individual donors who recognize why we fight for fair, accessible, and transparent courts. Thank you in advance for your support, and thank you to Attorney General Raoul and Chief Justice Burke for being here today. Now I'll turn to my Goldberg colleague and fellow Chicago Appleseed board member, Harleen Kaur, to introduce our first speaker.
Thank you, Roger. I'm excited to introduce the first of today's two keynote speakers, Illinois Attorney General Kwame Raoul. Attorney General Raoul was sworn in as the 42nd Attorney General of Illinois in January 2019. Born in Chicago to Haitian immigrants, the Attorney General brings a lifetime of legal and policy experience, advocacy, and public service to the office of the Attorney General. As the state's chief legal and law enforcement officer, Attorney General Raoul has worked to reduce the long-lasting effects of violence and provide support to survivors of harm and their families by improving Illinois' crime victims compensation program to ensure that the process is trauma-informed and reaches all communities across the state. He also increased the funding for grants under the Violent Crime Victims Assistance Program, which provides financial support to government and nonprofit social service agencies throughout Illinois that offer services to victims and witnesses of violent crime. In addition to these efforts, Attorney General Raoul has focused on enhancing collaboration between the Attorney General's office and federal and local law enforcement agencies, has taken a leadership role in addressing the unique multi-jurisdictional issues that have arisen through the COVID-19 pandemic, has utilized a multidisciplinary collaborative approach to protect children from online threats, and more. As Attorney General, he has engaged in multi-state efforts to defend access to quality healthcare for all, to defend consumer protections, to protect our natural resources from rollbacks of environmental protections, to fight for immigration policies that do not separate children from their families, and has been a leader in defending and protecting the rights of working people in Illinois. Before being elected as Attorney General Raoul spent 14 years serving as a state senator representing the 13th Legislative District. As a senator, AG Raoul led negotiations and sponsored many significant measures that became law, including those to abolish the death penalty, to require mandatory background checks on private transfers of guns, as well as law enforcement and criminal justice reform, workers' compensation reform, and some of the strongest voting rights protections in the nation. Thank you for being here today with us, Attorney General.
Thank you, Harleen. Good afternoon. Thank you for inviting me to speak in such illustrious company as Chief Justice Anne Burke, and to such an esteemed audience as the one gathered here virtually. Lawyers and activists doing the daily work of balancing the scales of justice. I fear that I may be preaching to the choir today, but I want to share some of my office's efforts and experiences in the interest of expressing my gratitude towards those of you who are in the trenches, and also in the interest of persuading anyone sitting on the edge to jump in and help in a sustained manner. We know that access to counsel makes a significant difference in outcomes. This is true in matters both civil and criminal. In eviction proceedings, for example, 90% of landlords are represented by counsel, while only 10% of tenants are similarly situated. The result is that in most jurisdictions, the vast majority of filings result in an order for the tenant's eviction from the property. And that doesn't count the frequency in which self-help eviction, such as changing the locks or simply putting an eviction notice on a door, is successful in causing the tenant to leave without a court order, without court relief. According to a Lawyers Committee for Better Housing analysis of Cook County data from 2010 to 2017, residential tenants lost their cases 62% of the time when unrepresented by counsel. With an attorney advocating for them, tenants were evicted only 45% of the proceedings. Eviction is just one of the many legal scenarios that are not criminal in nature and thus do not invoke the Constitution's right to counsel, but in which a party's fundamental well-being may be at stake. Other examples include some of the actions to terminate parental rights, immigration proceedings, benefits hearings, divorce, and child custody hearings. Right to counsel is guaranteed when a person has been criminally charged. But it would be naive to imagine the indigent defendants always encounter a fair playing field simply because they have been assigned a public defender, who in most cases are able lawyers, but in many cases are likely underpaid, under-equipped, and overburdened with cases. Because access to counsel matters so much, my office serves as the appropriations hub for funding that goes to the Illinois Equal Justice Foundation to fund legal aid initiatives. But lack of representation is not the only obstacle in the way of fair access to justice. We know that implicit bias pervades the justice system. When judges in a 2009 study took the racial implicit association test, designed to measure subconscious bias, they performed similarly to the general public. The level of subconscious racial prejudice judges in the study harbored was no less than that of Americans who were not so thoroughly trained in the law or tasked with reflecting on fairness and equity while holding lives in balance. Fast forward out of the controlled environment of the lab and onto the streets of Minneapolis in 2020. And our nation went through a reckoning following the murder of George Floyd under the knee of a police officer sworn to protect and to serve. And perhaps the best way to reflect upon what we learned or didn't learn from this tragedy is to imagine that a 17-year-old girl had not been present and had not had the courage to record the incident on her phone. Consider then what the initial police reports would have looked like and who would have been believed, even if witnesses had come forward. We get a glimpse from the initial statement of the Minneapolis Police Department. The statement said that Floyd physically resisted officers and appeared to be suffering medical distress after he was handcuffed. Now, it neglected to mention the use of force used by Derek Chauvin, or that Floyd pleaded that he could not breathe. Instead, characterizing the situation by indicating that at no time were weapons of any type used by anyone involved in the incident. We can imagine what justice would have looked like without any videotape. There's a level of subconscious bias many of us would have that would lead us to easily conclude that there was nothing inappropriate about the interaction between the Minneapolis Police Department and George Floyd on that particular day. And many of us may want to believe that we would have our suspicions about something inappropriate having transpired on that day. But instead, we would balance the credibility of a veteran police officer and his partners against the credibility of inexperienced bystanders. We might be dismissive of the incident altogether based on Mr. Floyd's criminal activity, his criminal background, and his alleged use of controlled substances. That's why it's important to pursue a long-term, deliberate, and committed push toward law enforcement reform, one that marches onward when the public is paying close attention and also when they're not paying attention at all. The Office of the Attorney General has engaged in this work through many avenues, including the Chicago Police Department consent decree implementation and law enforcement certification legislation that creates stronger mechanisms for accountability and for transparency. We are in the process of exploring the establishment of a statewide conviction integrity unit because we know that not just public defenders, but local prosecutors can be overburdened as well. On the civil side of the equation, my staff works tirelessly to offer constituents information and advocate for them whenever possible in areas such as access to healthcare, fair housing, disability rights, other civil rights concerns, consumer disputes, and also in workplace issues. The services my staff provides have been a lifeline during the pandemic in particular, when many residents face unfamiliar challenges, from PPE scams to price gouging to unsafe working environments. They needed answers and advocacy, which we provided. In March of 2020, most of us went home to work remotely, but we didn't shut down. My staff found ways to remain responsive to all of these inquiries. Imagine if essential workers in warehouses, food processing facilities had to advocate for themselves as the rules and our knowledge of the virus changed weekly and even daily in some cases. But as much as we do for individual consumers and workers, we cannot do it all. We represent the public interest. We do not have the capacity to represent every harmed individual directly. So that means that we cannot single-handedly level the playing field for pro se litigants or counteract the effects of implicit bias in the justice system. Instead, we rely on nonprofit groups and individual lawyers to represent people, take on the cases we cannot, and gather the data and experience that inform our advocacy work. We look at these people as partners. At this time of reckoning, many in the legal profession have asked, what can I do? That study of judges and their subconscious biases offered one optimistic data point. When the same group of judges who had demonstrated implicit bias were made aware of the experiment and given a hypothetical scenario in which the race of the defendant was made explicit, they tended to course correct and to issue far more even-handed decisions. No matter what position you occupy in or with respect to the justice system, one thing you can do now is become aware of your own biases and take deliberate, well-informed steps to reduce the effect of our environment of systemic racism on your decision-making. We have made an effort to help the lawyers in our office recognize the biases with which they may have come to the office or developed during the course of their tenure, for that matter. We hosted Dr. Erin Reeves as she presided over a training that allowed our staff to look in the mirror and examine how they might unconsciously allow prejudices impact their approach to seeking justice for citizens of the state of Illinois. In doing so, I wanted to make sure we weren't simply engaging in box checking for CLE purposes, but I wanted them to really engage in self-reflection and self-examination. I wrote a very personal letter to my staff and confessed to the fact that I had on many occasions suppressed complaining about injustices for fear of being characterized as an angry Black man. I felt that I had contributed to the lack of access to justice by way of tolerance. All of us involved in the justice system need to engage in a very honest look in the mirror. We need to examine where we have been tolerant to injustices because we felt nobody would notice, or alternatively, where we have been guilty of unconscious bias ourselves. After doing so, make plans to involve yourself in sustained action for change. Not just the minimum pro bono hours or activities you need to remain in good standing, but a commitment to bring your talents to bear on the great challenges of this time. The demands for reform swing back and forth like a pendulum. My greatest fear is as high-profile instances of injustice recede farther into the past, is that the passage of time will reduce the urgency to reform the systems that allowed them to occur in the first place. When the American public views disturbing, outrageous images such as the recorded death of George Floyd, the shooting of Laquan McDonald, passions become inflamed. But after a while, they burn out. We see it going on right now. As a result of a rise in violent crime, the interest in and popularity of law enforcement and criminal justice reform begins to wane. We even begin to blame the reforms, some of which have yet to be implemented, for a rise in crime. This grows out of and feeds off of a false dichotomy that suggests that if you work for law enforcement reforms or sentencing reforms, you are working against police or law enforcement. Listen, I am just as outraged by what seems to be an uptick in vehicular hijacking, expressway shootings, violent looting, and other violent crime as anybody else. I very much value my law enforcement partners. I share the same passion for holding violent criminals accountable as I do for law enforcement reforms, because I realize we must engage in both and that they are intertwined. If we do not restore the public trust in law enforcement, we clear less cases because we have less public cooperation with police. Ensuring access to justice requires a more careful tending of the flame. It requires honest self-examination of our own acts or omissions, which may have undermined access to justice. It requires a long-term commitment. It requires pro bono efforts, which we pursue with the same zeal that we may have for the case of a well-paying client. It requires collaboration with people and institutions with whom you might not immediately agree, but whose buy-in is necessary and whose perspectives can be valuable. And it requires productive partnerships like the ones my office has with many of the justice efforts that you support. Thank you for doing this work and for inspiring more attorneys to step up and to do likewise. And thank you for allowing me to address you this afternoon.
Thank you again, Attorney General Raoul, for those insightful comments and for that reminder of the call to action for all of us to help combat the systemic issues in the civil and criminal justice systems. Now I'd like to turn this over to our second keynote speaker, Chief Justice of the Illinois Supreme Court, the Honorable Anne Burke. Chief Justice Burke is a member of the Illinois Supreme Court representing the 1st Judicial District. She was appointed to the Supreme Court on July 6, 2006, and was elected, then retained, in 2008 and 2018, respectively. In September 2019, she was elected by her colleagues to serve as Chief Justice of the Illinois Supreme Court, and on October 26, 2019, her 3-year term commenced. Chief Justice Burke's judicial career began in 1987 with an appointment to the Illinois Court of Claims by Governor Jim Thompson and a later reappointment by Governor Jim Edgar. Prior to joining the Supreme Court, Justice Burke served on the appellate bench until 2006. Before serving on the Illinois Appellate Court, Justice Burke was special counsel for Child Welfare Services under Governor Jim Edgar and was a member of his legislative committee on juvenile justice. She provided in-depth leadership in reshaping and improving the Illinois juvenile justice system. Prior to her judicial career, Justice Burke was a physical education teacher with the Chicago Park District, where she worked with children with learning differences. Having recognized the positive impact that sports competition had on her students, she championed the idea of a citywide competition, which ultimately led to the creation of the Chicago Special Olympics in 1968, growing later to become the International Special Olympics, reaching tens of millions of people in 192 nations across the globe. She later served as a director of the International Special Olympics and remains involved with the Chicago Special Olympics to this day. Between 2002 and 2004, Chief Justice Burke served as interim chair, directing the efforts of the National Review Board of the United States Conference of Catholic Bishops in its investigation of the causes and effects of the clerical sexual abuse scandal, and helped to establish guidelines and policies for effectively responding to this scandal. She currently serves on the Executive Steering Committee of Kennedy Forum, Illinois. Thank you for being here with us today, Chief Justice Burke.
Thank you, Harleen, for that very kind introduction. It is my pleasure to be with all of you today. First, let me say how much I enjoyed General Raoul's presentation. It was extremely positive and informative and powerful. Thank you so much for being our Attorney General. The general topic of today's discussion is eliminating disparities and ensuring justice for all in Illinois courts. With that in mind, I will be speaking to you about a matter that will greatly impact our judicial system, judicial redistricting, and also I will be speaking about our new statewide pretrial service program under the Safety Act, which will improve the delivery of fair and equal justice throughout our state. So I hope you received the 2 handouts with your registration materials. If not, these handouts are accessible as attachments to this live stream video. The first attachment depicts the map of the old and the new judicial districts. These old and new judicial maps illustrate the significant changes in the new Supreme and Appellate judicial districts. The second attachment depicts our 102 counties, which are color-coded according to those counties that have established pretrial services, those who have limited pretrial services, and those that currently have absolutely no pretrial services available in their county circuit courts. And I will be referencing these maps in my remarks. So with regard to redistricting, You should know that in 1970, the Illinois Constitution, in Article 4, Section 2, divides the state into 5 judicial districts for the selection of Supreme and Appellate Court judges, with Cook County comprising the 1st judicial district and the remainder of the state, as set forth in the Constitution, to be divided by law into 4 judicial districts substantially of equal population, each of which shall be compact and composed of continuous counties. Now, while the talk of redistricting the judicial districts have been discussed from time to time over the decades, the 4 districts outside of Cook County have remained the same since the old judicial district map was enacted in 1963. So after the 50 plus years, the population of Illinois, we know, has truly changed greatly. Therefore, to meet the requirements of Article 4, Section 2 of the Constitution, and to ensure more equal representation for the citizens of this state, the legislature saw fit to enact the Judicial Districts Act of 2021, which redefines the boundaries of the 4 judicial districts outside of Cook County based on population as it is today. The legislation passed both houses on May 28, 2021, and was sent to Governor Pritzker for approval on May 30th, 2021. However, the legislature passed the redistricting legislation without notice to or input from the Supreme Court. In addition, the legislation provided that was to take effect upon becoming law. Thus, on June 4th, 2021, when the Governor Pritzker signed this historic new legislation into law, the act immediately went into effect. By providing that the act was to take effect immediately, no consideration was given to the significant logistical challenges that would be necessitated by such significant changes to our judicial districts. Further, the legislation was an unfunded mandate. That is, no funds were allocated to defray the cost of implementing these dramatic changes. So the Supreme Court recognized that it would be impossible to implement the Judicial Redistricting Act of 2021 instantaneously. For this reason, the court entered an order on June 7th, pausing the new legislation from going into effect, thereby giving the courts time to prepare to implement the new boundaries. And the pause order provides in pertinent part. In view of the numerous changes to the processing of the appeals and the administration of the justice system in Illinois, necessitated by Public Act 102-0011, including but not limited to updates in e-filing and case management system software, redistribution of staffing and judicial resources, to training of judicial stakeholders and education of the public and members of the bar, and to give sufficient time to plan and implement such changes required by the Public Act, and to facilitate an orderly transition, avoid errors, and guarantee access to justice, the court ordered that appeals and all other matters shall continue to be filed in the judicial districts as they existed on June 3rd, 2021, until further order of court. Now that you know what happened and how it happened, I would like to discuss some of the resulting consequences, whether intended or unintended. So let's look at the old and the new maps. As can be seen from these maps, the changes to the 4 districts outside Cook County are quite remarkable. The 5th Judicial District now stretches from Cairo to Champaign, a distance of close to 250 miles. The 4th Judicial District now extends from Jerseyville to Rockford, an even further distance of over 275 miles. Also, the redistricting moves 1/3 or 8 of our 24 judicial circuits into a whole new appellate district. As I am sure you can appreciate, these dramatic and sweeping changes create significant logistical challenges for our entire court system. Because of the complexity of these challenges, we created a judicial redistricting task force composed of circuit and appellate court judges, county clerks, sheriffs, and other stakeholders to study and report on the impact of the new map and to provide recommendations for moving forward. The task force was formed to identify the extent of the logistical challenges we faced and develop an action plan, and also assess the financial consequences of these changes. In addition to the task force itself, multiple subcommittees have been formed to address the specific needs of the various court branches and of stakeholders affected by the redistricting of the legislation. For example, the Circuit Courts Subcommittee is tasked with approximating the needs and associated costs that redistricting will impose on the operation of the 8 judicial circuits that will be moving to a new appellate district due to the new judicial district boundaries. And those judicial districts are the 5th, the 9th, the 6th, the 7th, the 14th, the 15th, the 17th, and the 18th. An additional subcommittee was formed to review the impact of the judicial redistricting on the private bar, legal aid, and self-represented litigant communities. The subcommittee is tasked with identifying any needs or issues that must be addressed, and without outlining a plan for any educational efforts or administrative modifications that need to be made. Then there's an additional procedural issues committee. It has also been formed to address the appellate procedural issues once the pause order has been lifted and appellate district is changed to the new map. For example, we need to decide how to handle appeals that originated from a county that was in one appellate court district prior to the redistricting, but once the pause order is lifted, will it be in entirely different appellate district? These subcommittees have been working diligently, and I have been working and reporting with them their recommendations for the constituent groups. In turn, the director of the administrative office and myself, Marcia Meese, have met in Springfield with the majority and minority leaders to present our plans and our reports for the implementation of the Judicial Redistricting Act. At present, the pause order has not been lifted. Nevertheless, the judicial branch is forging ahead with preparations to meet the challenge of the transitioning to the new districts and boundaries, while ensuring that our courts maintain access to justice pursuant to the powers and duties entrusted by the Illinois Constitution. So we're all just kind of waiting to lift the pause order. The pretrial services now, I'm moving to my next topic, on January 1st, 2023, as noted before by the General, will become the first state in the nation to totally eliminate cash bail, pursuant to Governor Pritzker's signing of the Safety, Accountability, Fairness, and Equity Today, or SAFETY Act, on February 22, 2021. Contained in the Pretrial Fairness Act component of the SAFETY Act is a mandate that all persons charged with an offense shall be eligible for pretrial release before conviction. Pretrial release may only be denied when a person is charged with an offense listed within the act, or when the defendant has a high likelihood of willful flight, and after the court has held a hearing under section 110-6.1. Although the Pretrial Fairness Act provides that the Supreme Court may establish a statewide risk assessment tool to be used in proceedings to assist the courts in establishing the conditions of pretrial release, the Supreme Court found it imperative for Illinois to have a statewide legal evidence-based pretrial system in place once the SAFETY Act goes into effect, to fully support the judiciary and other system stakeholders in making the appropriate and informed pretrial release decisions for supervising defendants released into the community. And currently, our system for providing pretrial services is governed by a Pretrial Service Act that went into effect on July 1st, 1987. The statute states each circuit court shall establish a pretrial service agency to provide the court with accurate background data regarding the pretrial release of persons charged with felonies and effective supervision of compliance with the terms and the conditions on release. Despite the fact that the Pretrial Service Act has been in place for 34 years, much of our state still provides little, if any, pretrial services. So I want you to look at the pretrial service map now that I've provided. This is mainly because the majority of our circuit courts serve rural populations, and counties do not have sufficient resources to comply with the act. So to address these unmet needs, my court, the Illinois Supreme Court, announced on August 20th, 2021, that we plan to adopt a new statewide operational structure for pretrial services in adult criminal proceedings. The court, with assistance from the Supreme Court Pretrial Practices Implementation Task Force, considered several different models for the provision of pretrial services when the Safety Act takes effect on January 1st, 2023. In the process, though, of selecting a model, the court determined that placing the operational structure for pretrial services under the supervision of a single entity, the administrative offices of the Illinois courts, and by implementing this new structure in a phased approach, we could best achieve a more equitable statewide pretrial service practice. We believe that a centralized entity to oversee the provision of pretrial services is critical to the success of the program and also will ease the burden on the counties facing the unfunded mandates and decrease the revenue due to the elimination of cash bail. As it's this court's intention, through this new operational structure, the procedures and practice employed in the circuit courts throughout Illinois will be applied equally, will be fair, efficient, transparent, accountable, and adequately resourced using legal and evidence-based practices. We will transition pretrial services to a statewide system in 3 phases. In phase 1, we will address the needs of the 50+ counties that currently operate with minimal or absolutely no pretrial services. And we will also assist other counties that currently have pretrial services but wish to join the state system by January 1st, 2023. Counties with limited pretrial services will comprise phase 2 and will join the state system by January 1st, 2024. Remaining counties that already provide more robust pretrial services will make up phase 3 and will join the state system by January 1st, 2025. Considerable work has already been underway to build this new operational structure for statewide pretrial services. The Illinois Supreme Court has named retired Circuit Court Judge Cara Lefevre-Smith, a director of the new office. She's the director of the new Office of Statewide Pretrial Services, and Wendy Vanderloth, a deputy director. Judge Lefevre-Smith served as a Cook County Circuit Judge from 2019 to 2021, starting in the 1st Municipal District and then moving on to Juvenile Justice Division. But before joining the bench, she served as the Chief Policy Officer for the Office of the Cook County Sheriff. Wendy Vanderloth was previously the Administrative Office's Pretrial Services Administrator. She started her career in 1999 with Adams County Probation and later was named Director of Probation and Court Services for Adams County, overseeing the establishment and continued operations of that county's pretrial department. The statewide pretrial services leadership team includes retired Judge Robin Stuckert, who will serve as a consultant. Judge Stuckert chaired the Illinois Supreme Court Commission on Pretrial Practices and now chairs the Pretrial Practice Task Force to implement the recommendations from the Commission's April 20th, 2020 final report. In addition, Sarge Rizvi will serve as pretrial services administrator. Sarge joined the administrative office as a pretrial service manager in 2020. His knowledge and experience regarding legal and evidence-based pretrial practices will be a great asset to our program. The new Office of Statewide Pretrial Services is a historic initiative designed to fulfill the requirements of the likewise historic Safety Act. Plans for additional staffing, infrastructure, and training are being established, and there is much work to be completed on many fronts before the counties in phase one will be ready when cash bail will be eliminated on January 1st, 2023. Also, we've had some listening tours that have begun throughout the state to meet with the local justice system stakeholders and to hear their questions and feedback regarding this massive undertaking. The court strongly encourages the participation and input of judges, attorneys, pretrial practitioners, state and local law enforcement agencies, persons with lived experiences in the criminal justice system, and the crime victim service organizations. In order to make this outreach and effort informative and meaningful for all, we need to hear from everyone. The Supreme Court, the Administrative Office of the Illinois Courts, and the Office of Statewide Pretrial Services are committed to supporting every county in Illinois to ensure the successful implementation of the Pretrial Fairness Act provision within the Safety Act through reimbursements, through ongoing comprehensive training in each of the phases, and by maintaining an open dialogue with all Illinois circuit courts, court system stakeholders, and the public. It is our sincere hope that statewide pretrial service system will provide a structure that not only supports the mandates of the Safety Act, but also fosters public safety while ensuring constitutional safeguards. Thank you so much for your commitments to these efforts, and thank you so much for your service. And if you have any questions, please call the Office of the Statewide Pretrial Services for Justice, and thank you for listening today. Thank you.
Good afternoon. My name is Malcolm Rich. I'm the Executive Director of the Collaboration for Justice of Chicago Appleseed Center for Fair Courts and the Chicago Council of Lawyers. I want to thank our sponsors for our Hidden Injustices events this month: Baker McKenzie, DLA Piper, Harrison and Held, Jones Day, Latham Watkins, Neon One, PwC, Schiff Harden, Sidley Austin, Shook Hardy Bacon, Goldberg Cohn, Matt Daniels, Candace Corcus, Dr. Mary Patillo, Laura Davis, Aviva Fitorian, Emily Gilman, Sonia Nahr, myself, Julia Waterhouse, and all the anonymous or other donors. Our Collaboration for Justice would not exist but for you. For nearly 25 years, a collaboration of Chicago Appleseed Center for Fair Courts and the Chicago Council of Lawyers has fought to make our courts less harmful and less racist, and more accessible and fair. Our focus includes reducing the harm of the criminal legal system and the immigration courts, improving the family law and child support systems, and promoting accessible justice and police accountability. I helped create this collaboration. Our mission was important at the outset. It is even more important now. There is unprecedented interest in the diversity, in the fairness, and in the independence of our courts. An insidious web of injustices has led to mass incarceration, a huge percentage of persons unable to afford legal counsel, facing an unfair playing field in our courts, and a legal system that too often entraps people with court costs and fees and fines. The Collaboration for Justice will continue to work to identify these injustices and find solutions. We want to successfully end money bond, dramatically increase legal representation of those persons arrested and being held in police stations, stop police perjury in our courtrooms, propose a better use of problem-solving courts, increase the use of administrative hearing officers in domestic relation courts, those division courtrooms in the domestic relations division of the Circuit Court of Cook County. We want to do that to level the playing field for unrepresented parents. We want to improve their domestic violence courts. We want to monitor the implementation of a legislatively imposed waiver of court costs and fees for indigent persons in the criminal division courts. And we want to introduce expanded and research-based community court watching and judicial evaluation. I ask those seeing this program to help us. Donate your time and donate your money. For lawyers, please do two kinds of pro bono work every year: individual representation and systemic reform. Help us improve lives by improving courts. Please donate by using the donate button now on the collaborationforjustice.org site where you are now, or go to www.chicagoappleseed.org/donate. And to get involved, please email us at caffj@chicagoappleseed.org. That's caffj@chicagoappleseed.org. Thank you to our speakers. Thank you to all of us who put this together, but also thank you for joining us this afternoon. Thank you.